Senate Judiciary Committee will come to order. The clerk will call the roll.
Senator Saslaw.
Here.
Senator Normant.
Here.
Senator Lucas.
Here.
Senator Obenshain. Senator McDougal. Senator Stewart. Senator Stanley.
Here.
Senator Deeds.
Here.
Senator Peterson.
Here.
Senator Serval.
Here.
Senator McClellan.
Here.
Senator Boysko. Senator Morrissey. Senator Peake.
Here.
Senator Edwards.
Here,
Mr. Chair, you have a quorum.
we have a quorum. How many real people that are here? Okay, McDougal can't, we know that McDougal cannot come, but we do have a quorum. First of all, I want to welcome our new clerk, Sean Sukkel. Raise your hand. And also Shannon Hurd Rosser. She's got a new name, Shannon, not just Shannon Hurd, but Shannon Hurd Rosser. Congratulations. She's the judge selection administrator. Everybody knows Shannon. She's doing a fantastic job. The other people is watching online, I believe, Charles Quigliato, DLS, Kristen Walsh, DLS, and Steve Benjamin, who's our counsel. We're delighted today to have an opportunity to hear Christy Wright, the program director for the Office of the Executive Secretary of the Supreme Court. And she's here with Justice Cleo Powell. Welcome, Justice Powell, and retired Judge Ellen White. And they're here to give us a presentation concerning the Judicial Performance Evaluation Program. So, Christy, welcome, and appreciate the opportunity that you've given us to hear what you have to say.
Thank you. Thank you very much. We appreciate the opportunity as well. Is it okay that I keep my mask on?
Yes, you can
Okay.
take, yeah.
All right, thank
I think
you.
it's far enough away.
Okay.
Anyway.
Well.
And I'm sure you've been vaccinated like everybody else here. So go ahead. Thank you.
Yes, so my name is Christy Wright. I'm the program director for the Judicial Performance Evaluation Program in the Office of the Executive Secretary at the Supreme Court. As Chairman Edwards mentioned, Justice Cleo Powell of the Supreme Court is here today, as well as retired Judge Ellen White. She's a retired J&DR judge, and she's also a facilitator for the JPE program. The current program has been in operation since 2014, and beginning in 2017, all judges seeking re-election have had evaluation reports submitted to the General Assembly. From 2014 to 2017, there were judges being evaluated, but their reports were not coming to the General Assembly because those reports were initial or interim reports. And the legislation enacted in 2014 requires that a judge have an interim report before the final one is reported to the General Assembly. In addition, since 2014, we have begun appellate evaluations. In 2016, the appellate evaluation plan was approved. In 2017, the pilot was completed. Evaluations began in 2018, and then this last year in 2021, there were evaluations for 2 judges of the Court of Appeals in the report to the General Assembly. Pursuant to Code 17.1100, the Supreme Court is responsible for the JPE program. Administration of the program is provided by the Office of the Executive Secretary, which in Virginia is the administrative office for the courts. In May of 2015, the court entered an order creating the JPE Advisory Committee to provide advice to the Chief Justice in the operation of the program. And that advisory committee is chaired by Justice Powell, and it's made up of judges from all levels of court, a retired judge, a circuit court clerk, an attorney, and 2 ex officio members who are also attorneys. And right now the membership stands at 17. And the committee looks at all aspects of the program to see where improvements can be made. And to assist it in doing so, there are 5 subcommittees: the anti-discrimination, anti-bias, the appellate evaluation, evaluation report format, survey instrument, and survey respondent subcommittees. Now, the program has 2 goals. One is to provide information for the judge for their own self-improvement, and the second is to provide a source of information to the General Assembly in the re-election of judges. The confidentiality of those the initial and interim reports is set out in Virginia Code Section 17.1-100. In 2014, the General Assembly decided that all evaluations leading up to the final evaluation should be confidential. And we wholeheartedly agree with that. It is only the final evaluation that comes to the General Assembly and is made public. In addition, the reports are made not public under 2.23705.7. So why does confidentiality matter? Wanted to talk a little bit more about that today. Judges are evaluated 3 times. For a judge in their first term, that's an initial evaluation, an interim, and then a final. The interim and initial evaluations are confidential, and they are used only for self-improvement. Now, there has been some information and some confusion, I think, about who actually sees the initial and the interim evaluations. Senator Morrissey had sent a letter to members of the committee and copied us and noted that the Supreme Court only the Supreme Court sees those interim evaluations, and that is not correct. The Supreme Court nor staff at OES see those initial or interim evaluations. Only the evaluated judge and the facilitator judge, and I will touch more on that, the facilitator judge's role shortly, but only those 2 people see those evaluations. As I mentioned, because one of the goals of JPE is self-improvement, it's akin to any kind of employee evaluation. So an employee who has a performance review can learn what he or she is doing right, and they can learn what they need to work on. And as any employee, if I have an employee evaluation, I'm going to work on that. My employer is going to want me to work on that. That employer has invested in me, whether it's time and resources to train me, to get me to perform well in that job. A good employer will not take that evaluation and post it in the lunchroom. They won't fire me because I have some improvement that needs to be made. It benefits both the employer and the employee to make sure that the corrections in action are taken by that employee. And the situation for the judges is really no different. The General Assembly has elected that person, that judge, because they believe that judge has the demeanor, the character, the experience, and substantive knowledge to perform well as a judge. If that judge is struggling in performance, the judge needs the opportunity to self-improve. And they need to be able to do that without the distractions of being in the public spotlight. Now, if the criticism relates to a judge's misconduct, ethical performance, or serious or mental physical disability, those concerns are appropriately addressed through the Judicial Inquiry and Review Commission, created under the Constitution to handle exactly those types of complaints. That is different than what we deal with the judicial performance evaluation. I know there's been discussions of publicizing and making public those interim evaluations, but to do so would increase the likelihood that those results would be used to undermine that judge and really to diminish the confidence of the public in the judiciary as a whole. And unlike the press or the public, who are not bound by the canons, judges are bound by the canons of conduct for Virginia's judges. It places them in an untenable position because they cannot address those concerns. They need to stay silent to them. And so the Commonwealth, as I said before, has invested in that judge, and the judge should have the opportunity to self-correct. And in a judge's first term, having those 2 opportunities to learn before that final evaluation is made public is really important. Now, just briefly about the evaluation process. So in a year that judge is going to be evaluated, we identify them. They are asked to complete their own self-evaluation. Those who are eligible to complete the evaluation surveys are then identified for each judge, because that's going to vary from judge to judge as they appear in different parts of the state. Each judge has a unique set of evaluators or respondents. The evaluation surveys are then distributed. The responses are collected and compiled over several weeks, and really several months for the juror surveys that are done for circuit court judges. The reports are then prepared for each judge, and they're distributed to the evaluated judges and their facilitators. The facilitators observe and meet with the evaluated judge. And so altogether, this whole process can take several months. So just a little bit more in how often they're evaluated. Judges in their first term, as I mentioned before, 3 times. It's after their first year, their midterm, and during the year before their reappointment. Judges in their second or subsequent terms only have 2 evaluations, so it would be their midterm and then their final. The annual list of judges to be evaluated during the year is then divided into what we call cohorts, and that's really for the purposes of management. And those cohorts generally average between 25 and 40 judges, and in a year, we're completing approximately 140 to 160 evaluations. Those numbers can change, based on retirements and elevation to a higher level of court. So who is it that's evaluating the judges? The types of evaluators vary by the type of court in which a judge serves. In a trial court, attorneys, bailiffs, and court reporters complete surveys for all levels of court, for both district and circuit. For circuit court judges, jurors, and in-court clerk's office staff also complete those surveys. Now, the appellate process is a little bit different, with appellate justices and judges being evaluated by attorneys and circuit court judges, and then their opinions are reviewed by the Appellate Opinion Review Committee. We contract with VCU's Survey and Evaluation Research Laboratory, otherwise known as VCU Searle, in the L. Douglas Wilder School of Government and Public Affairs. The reports are sent directly to the judges, and I'm going to reiterate again, we never receive those interim, either the initial or the interim, we never receive those. But for the final evaluations, we only receive those a couple of days before they are due to the General Assembly. We package it up essentially with a cover letter from the Executive Secretary, and we submit them to you all. Performance is measured with 23 different performance factors that are used and they are based upon the canons of conduct. The reports that you receive December 1 of each year shows those different performance measures. And it might be, the judge is patient, the judge is knowledgeable on the law. Those are the types of things that we're asking about. The performance measures that we use were recommended by the task force where all this began with JPE back in 2001. And they were developed after looking at other JPE programs in other states and in recommendations of the ABA, the American Bar Association. We also participate with the JPE working group. It's a national working group of representatives from other states that have JPE programs. And it's operated under the auspices of the Institute for the Advancement of the American Legal System at the University of Denver. It really gives a broad perspective. We work with states in different ways they use judicial performance evaluations. Many of those states, judges are popularly elected. But the Institute and the working group are really valuable resources to the latest issues and research for JPE programs. Now, the rating scale that we use and that you see in those final reports is a frequency-based measure. Research shows that the use of frequency-based measures, such as every time, frequently, some of the time, never, make the responses more objective and are less susceptible to inherent bias on the part of the survey respondents. Prior to using this frequency-based measure, a descriptive measure was used, so it was like excellent, good, that sort of thing. And each report that you receive also notes the number of surveys completed, and it shows the distribution of the responses for each frequency measure. Now, when you're reviewing these reports that we submit to you each December 1, I'd like to make some suggestions for how you might look at this. And the first is that while we know it's tempting to take the survey results or the reports and rank the judges from 1 to 100, it's important for you to understand why they're not comparable to one another. So each judge, including the judges within the same circuit or district, are evaluated by different people, and there are individual differences in how each of those people would rate a judge. So each judge's evaluation is unique and is not directly comparable to another's. So while the groups of people, the types of people are the same, you have attorneys, bailiffs, court reporters, say on a district court judge of doing the evaluation, the actual individuals who are completing those surveys can be very different, and can be different even within the same circuit or the same district. So what my 80% might be your 60%. And so they are not directly comparable. Now, most of us have experienced a professor or a teacher, probably on an open-ended question or an essay, and how that professor is looking at that it's very subjective. This is not an exam that's a multiple choice where the professor has the answer key, there's a right and a wrong. You get to the end, the professor says, you got them all right, Mr. Smith, Mr. Jones, you got a 50%. That's not the case here. Again, it's subjective, and the completion of the surveys is based upon each individual observation and their opinions. Now, the number of attorneys surveyed and for whom a survey would complete it is also not uniform. And as I mentioned just in a slide prior, you'll see that the number of surveys completed can depend and can vary from judge to judge, even, again, within the same circuit. Generally, there are fewer attorneys to survey for judges who preside in rural areas. The other thing I want to note is the practice of law can be very different, and depending on where you're at in Virginia, as can the legal culture. And I would suspect that the legal culture in Northern Virginia is very different from that in a rural community. It just is. The legal culture can be affected by the caseloads, how strong or how heavy of a caseload there is, the familiarity of attorneys with one another, the number of attorneys per judge, whether it's a multi-jurisdiction circuit versus a single jurisdiction circuit, and how often then attorneys are going to be appearing in front of those judges. So if I am an attorney and I'm in a large jurisdiction where, say, there's 15 judges, the chances of me appearing in front of all of them at some point is lower than if I'm in a jurisdiction where it's the same judge that is always there. That's the only judge that sits in that particular district court. Another thing I would like to recommend is that you look at the first two columns together, combine those. That's the every time and the frequently score. And those are really your positives, right? So take a look at that. Another recommendation is to look at the overall performance and look at the changes in the judge's performance. While a judge may perform lower on a few specific performance factors, the overall assessment is instructive. Again, combining excellent and good together to get that positive score. Changes in a judge's performance. So when the attorneys complete surveys, they're looking back 3 years for circuit court judges and 1 year for district court judges. The last 3 years, say for circuit court judge, may be an important marker for how that judge is responding to those confidential interim reports. You know, if you are seeing that that there has not been improvement or it's gotten worse, that may say something, but it is important to look at that whole, all 23 of those performance factors. Now, in order to help the judge understand and really absorb what those reports say, we have facilitator judges, and they are retired judges who are subject to recall. They're selected by the Chief Justice. They receive training on their role as a coach. And their role is they review the evaluation report. As I said, on an interim and initial, they and the evaluated judge are the only two that see that report. They observe the evaluated judge in the courtroom. They facilitate discussion of those evaluation results, and they help them understand the results, and they identify ways that evaluated judge may improve. The other thing I want to note here, and it was something that Senator Morrissey had raised too, as far as support for judges beyond the facilitator. So a facilitator judge is appointed for that distinct occurrence of the evaluation report. New judges they are assigned a mentor judge, and they mentor them for the first year. And we have been exploring, and we're going to be implementing in this coming year, a peer-to-peer coaching program that will provide support for judges who request it with a trained coach. And that would be a sitting judge who has trained in that role. We recognize that state court judges face many professional challenges simply due to the nature of their profession. There's isolation, decision fatigue, vicarious or secondary trauma. And having this sort of confidential, collaborative relationship with a coach, we think will be very valuable. Judge White is here. We asked her to be here. If you had any further questions about, she's a facilitator judge. If you ask, have any questions about what happens in any of her experiences, I know she would be happy to share that with you. Lastly, this is our page on the judicial system website for JPE. There's the frequently asked questions, and I really recommend it's frequently asked questions for attorneys. It actually goes into even more detail than I have provided here for you today. The link to where you can find it is at the top. I recommend you look through it. If you have any other questions, this is my contact information. Please reach out. I'm happy to assist you and answer any questions that I can. And same for that now. Thank you.
Where's your link, the link you're referring to?
It's at the very top up there. It's at the top of the screen.
Oh, I see.
Yeah.
Oh, I see. Okay, www.vacourts.gov, et cetera.
Yeah.
Okay.
Yes, sir.
That'd be helpful. Thank you. I have a question. First of all, I have some questions. How many other states have programs like this? Do you know?
I believe we have around 10 other states that participate in the JPE working group. It is, I will tell you, and so I'm also new to this, and so I've sat into one meeting of that. But because Virginia is unique, that Virginia and South Carolina elect their judges through the General Assembly, it can be different from those places where they popularly elect them and how they use those JPE reports.
Okay. The other question came to me when I read it, the Appellate Opinion Review Committee, that's just for appellate judges, is that right?
Yes, sir, yes, that's a part of the appellate review. It's not just a survey, and so on that appellate review committee is a retired justice, a senior justice, a retired circuit court judge, a retired court of appeals judge, and a law professor who sit on that and do a review. The appellate judge or justice selects the opinions that they would like to have reviewed. The committee reviews them, and then you will see in the report, for example, for like Judge Beals or Judge Decker, who were evaluated this last year, there's a section in there with their comments on their opinions.
Now, judges go to Reno, Nevada. There's a program there. Is that right?
I'm sorry, I didn't understand you.
Judges, all judges, I believe, periodically go to Reno, Nevada for a judicial program. Is that right?
They can if they want to. I think we try and make some money available for that. I know that just given funding, it's not as extensive as it maybe would like it to be, but there are opportunities for those sorts of programs.
Do all judges, are they required to go early on anyway in their career?
No, I don't believe so. No, but we do have. So when you elect a new judge, they go through a pre-bench training. It really is like judge boot camp. And there's administrative stuff, there's substantive information that's they have to learn. And then, as I said, we put them with a mentor judge who is an experienced sitting judge to assist them in that transition.
Okay, good. Any other questions of Christy Wright? Okay, Judge Senator Boysko.
Thank you. Thank you for the presentation today. So, excuse me. Thank you for the presentation today. So as I thought I understood you saying that we should take it with a grain of salt, basically.
No.
No.
No. No, not at all. I mean, these are, I think maybe what you're commenting on is the ranking.
Yeah.
Yeah. That you can't rank, I hope I've explained, and I can talk a little bit more about why they're not comparable. It is not an objective sort of thing where there's always a right or a wrong answer. You and I are circuit court judges in the same circuit. Your evaluators, the individuals evaluating you, can be different than the people evaluating me. And so it could be that I have very high expectations, and I don't, this is the way it always is.
Okay.
And I'm going to rate somebody very harshly, and somebody else is going to, oh, they do okay. Yeah, I'm going to, they're fine. The other thing, we've talked about it, is if I'm an attorney who is in front of a judge in a locality, and I'm appearing in front of her all the time. I was in front of her 30 times this last year, and I come across, and one day she's had a bad day. Well, that's odd, because I know her. She must be having a bad day. Now, you get a chance to fill out an evaluation. If there's another attorney who is in front of that judge that one day, they also have the opportunity to complete the evaluation. And so you need to look at the totality of the evaluations, but I don't think that you can compare them.
Okay. May I ask a
Yeah,
follow-up?
Senator Boysko?
Thank you. So if someone has a year after year of similar range of scores, would you consider that to be fairly consistent? So if someone is consistently rated very high or consistently rated very low, would you take that as an indication of something being in total a more
Yeah, I mean, I
consistent and
I would think that you can, because, but you also have to, I mean, I would look to see if on a final, if they are saying that it has not changed, okay. I mean, if they're evaluating that and they're saying that judge has not changed, if they're saying there has been improvement, or maybe it's gotten worse. But I think that you have to allow that judge the opportunity to improve. To say to take it with a grain of salt would be to say that these are of no value. And that is not at all what we're saying. They're valuable in two parts. They're valuable for self-improvement, so that judge understands how others are seeing them. And then it's valuable to you in the end to see. And I think that, I don't know if, Judge White might be able to also talk about some of that from her experience as a facilitator, as, how judges have perceived themselves versus how others have perceived, the respondents have seen it.
Okay,
Thank
any
you.
other questions? Yeah, Senator Morrissey, I believe.
Good afternoon, Ms. Wright.
Yes.
First of all, thank you for coming today.
Uh-huh.
Thank you for your presentation, and thank you for the work with JPE. We recently evaluated exactly 50 judges, and what was, I thought, amazing was that to a judge, all 50 were evaluated, they thought that the JPE programs were helpful, were necessary, and had their full support. And that is a judge that got a top ranking to one that got a bottom ranking. So and almost every judge was asked about them, and they thought it was extremely helpful. So please continue that. Now, and also, I sent you a copy of a letter that I responded to my colleagues. That was a letter that I received from Judge John Martin. He was not trying to curry favor with me. I had made a suggestion to him about how we could help those judges that did not grade as well so that they would do better. And he was responding. And with regard to the evaluations, he said, he commented on the first two evaluations that are confidential. And this is what he said, and I want you to comment on that and see if you agree. I do not know the reason why the first two evaluations are kept from the General Assembly. If the legislature has the right to elect judges, it seems implicit it has the right to know how they perform. If the second evaluation went to the General Assembly, then the legislator who sponsored that judge could speak confidentially to the judge about changing his or her behavior on the bench. There is nothing like hearing, you may soon be unemployed to get your attention. Now, here's a judge that graded exceedingly well is saying to me and to others, he thinks the two evaluations should be shared with the General Assembly. You equate it to putting the poster in the lunchroom so that the colleagues can see that. I don't think the legislators think that they are lunchroom colleagues. Why shouldn't those two evaluations be shared? To at least, if not to the public, at least with the General Assembly.
Well, I mean, I feel like I explained it, and I mean, I can review it again. I think one thing, you asked me why this particular judge indicated that. My guess is he had pretty good initial and interim evaluations. So I think perhaps if he had struggled, which some judges do, making that transition from an attorney to a judge, but given the opportunity to improve, he may feel differently about that. Because there are two goals of JPE, one of which is self-improvement, those first two evaluations are designed and intended to be self-improvement. And as I mentioned, to put that out there, and I think what it does is it goes to that person who is reelecting them. I think it puts it more in the political spotlight.
You think notifying a legislator that some judge is discourteous, does not show partiality, does not show a fairness to fidelity to the law is not warranted?
I think you have that opportunity.
You're entitled to that opinion. I'm just wondering if that's what you're
I
saying.
think that you absolutely have that opportunity at the final. Absolutely, upon reappointment. But again, you all have elected that judge. That judge was an attorney who gave up their practice or their position prior, and you put them on the bench. At the time you put them on the bench, you believe they had the character, the demeanor, the knowledge to perform that job well. You need to let them, once those problems are identified, you need to let them, without being in the public spotlight, correct those errors. And that's part of what a facilitator judge is doing, too, is to helping them understand. And again, it may be something that Judge White can speak to.
No, I have a couple more, excuse me, I have a couple more questions for you.
all right.
Senator Morrissey, go ahead.
Mr. Chairman.
Yeah.
You mentioned that there's a difference between the culture of law in Northern Virginia versus Franklin County, and I agree. Mm-hmm. But would you also agree that the concept of fairness, courtesy, knowledge of the law, impartiality would be broader than a geographical location?
No, I mean, I think that, no, I mean, I think that those are standards that attorneys would hold, and those are things that people would try to achieve. They want fairness.
Irrespective of geographical
Absolutely.
location.
And because those are also things, those are performance measures that are based on the canons. Those judges are held to those standards by the canons.
Okay, follow-up question.
Okay, Senator Morrissey.
With regard to the individual judge who comes in, a retired judge who comes in to do evaluation, that's a one-day evaluation. Do you know what I'm talking about? As Judge Martin said, we receive a one-day observation in court by a retired judge in conjunction with each evaluation. Mm-hmm. Question, does that judge who is sitting on the bench know that the retired judge is sitting in the audience evaluating him?
Yes, I mean, probably, and definitely in juvenile court, because
Okay.
those courtrooms are
Follow-up
closed. They're going to
question.
know.
Would you not agree
Yeah, Senator Morrissey.
thank you, that judge who knows that the principal is in the room, excuse my
Example.
comparison, that the principal has just come into the room, won't be on his best behavior that day?
I mean, that may be, but there's also, what they're doing is they're looking at the self-evaluation, they're looking at the evaluation that they have received from from the attorneys, the bailiffs, the court reporters. For circuit court, it's jurors and in-courtroom staff, and they're talking with the judge about those results.
Yeah.
And again, Judge White has an example, and we were talking earlier about a judge who she did an evaluation for, and there had been a lower mark on that the judge pays attention. And while Judge White, and she can say it, or I can tell you. You wanna-
Go ahead.
May she come to the.
Finish your question, and
Okay.
then we'll go
All
from
right,
there.
well, so anyway, so she was looking at it appeared that she was looking out the window. And in fact, what it was, that is where the clock in the courtroom was. But Judge White picked up on that and said, what, it looks like you're not paying it. What are you looking at when you're looking out the window? She's like, what? And it was like, no, that's where the clock is. Didn't even occur to her that that's what was going on. I mean, it can be but to attorneys who are appearing before her, it seemed that she was not paying attention.
Okay.
But the judge so the facilitator judge was able to say, I noticed you doing that, and then she was able to correct it.
Sure.
It can be something as simple as that.
Final question, Mr.
Yeah,
Chairman.
okay, final question, Senator Morrissey.
Thank you. You mentioned that if there's actually some documented or alleged untoward conduct by a judge, then it goes to the Juror Commission, and that's a different matter. But how do you explain the fact that the Juror Commission evaluation and reports are also confidential? And as legislators, if a judge goes before the Juror Committee, we don't have the first evaluation, we don't have the second evaluation, we don't have a report from Juror Committee about that untoward conduct. And it's, to me, the only individual in our society that's being evaluated and tested, and that we don't get access to those records. Do you
Well-
not find that
Well,
perhaps
so
inconsistent with your argument?
No, not at all. Because the performance factors are not addressing ethical violations or a serious physical or mental disability. They're different.
Two different things.
And the JERC is established, that is separate, it's established under the Constitution. They have their own statutory language relating to them. That is not JPE, so I can't really address the confidentiality of those. But I do think it is different.
Okay.
Thank you very much.
Senator
Mhm, thank
Sherrill,
you.
I believe, has a question. Senator Sherrill.
Yeah, Mr. Chairman, thank you. I had some thoughts and I guess a question or two. And first of all, I appreciate the presentation. I've sort of been getting answers to how these things are generated through the last 3 or 4 years now, I guess, and this is more information that helps me understand how this stuff is arrived at. But first of all, I find the information we get extraordinarily helpful.
Good.
For a couple different reasons. One is because, I sit in a circuit that I think has, I represent a circuit that has, I want to say, 35 judges. So I can't appear in front of all them all the time to have a sense of what's happening.
Right.
I represent 3 circuits that probably collectively have over 100 judges easily between the 15th, the 19th, and the 31st. So the information is helpful to me. And I can only imagine that for people that don't practice law, trying to serve and evaluate these judges as legislators, this information is extraordinarily helpful to them so they don't have to feel like they have to rely on people like myself or Senator Peterson or Senator Edwards or Senator Stanley or whatever for what we anecdotally see in a courtroom. So I find the information to be very helpful. I also think the information helps to validate our views on what we see in courtrooms and help us to explain to the public why a judge perhaps might need to be removed if the judge consistently gets bad scores or has some bad rankings. And so the program is very helpful in that. I can tell you that in my experience, the rankings or the judges' ratings relative to each other, which you called rankings, tend to be consistent with my experience observing the judges. The judges who I perceive to be not very good judges tend to be at the bottom, and the ones who I perceive to be very good tend to be at the very top, and the ones that are kind of in the middle are in the middle. And I also appreciate the fact that, I've been to traffic court in some jurisdictions where there's one judge and everybody's in the back having coffee before court starts, and in Fairfax, that would be unthought of. And so I can understand that people might be more friendly with each other, and in some jurisdictions that are smaller, the judge might, as a whole, rank higher because everybody's friendly and nice to each other or something like that. I agree with all that as well. But when I first started receiving these from staff and I saw a report with a bunch of numbers on it, they were all completely meaningless to me without having the context of see how these judges juxtapose against each other or even other judges within a circuit. Because then I could start to have an understanding of the people in this circuit see this judge differently than this judge, and this judge and this judge, and relative to other circuits, they see them differently. And so, from my perspective, seeing how they rank relative to each other is very important in terms of understanding how they're doing. And I think it's very helpful to rank them. I understand that there's downsides to that, but as we get more and more data, now we're up to, I think, about 300 judges since 2017 that have been put through the system. The more data we get, I think the more valuable ranking gets because we start to get perspective. For example, I know we have at least one judge up this year that we were concerned about, and I have an evaluation of that judge from 2017 or whatever, 2016, 17, something like that, that I can compare against that judge's evaluation this year. And we're concerned about that judge, and the judge's numbers are almost identical. We got complaints then, we got complaints now, right? And so ranking and comparison, all that stuff helps. So that's just some commentary, right? And I would also just note that I cannot tell you how many practicing lawyers who I've spoken to who are terrified of speaking out because their clients are going to get punished for them opening their mouth. And they feel like they cannot publicly articulate the problems they see without fear of the judge punishing them next time they appear in front of them and then their client being hurt for it. And so a lot of lawyers feel very uncomfortable even reaching out to us to tell us things. And most of them say, I'm not going to tell you something unless you promise me you're not going to use my name. Right? And of course the judge gets angry when you bring these things up. I want to know who's saying this, and how am I supposed to respond to it if I don't know who it is and I can't put it in place and address it. And I think we've sort of reached some kind of an armistice or a compromise to try and get data the best way we can get it that protects everybody the way they need to be protected, which is, I think, how we arrived at where we're at.
May I say something?
Sure.
Yeah.
I got some more comments and then a couple questions.
Well, I was just going to, because
Chrissy, go ahead.
I think, but I want to make sure, continuing the misperception that the Supreme Court or OES sees those, and we're the ones
it's not.
behind the scenes tabulating.
I didn't say
That is not the case. And
Okay.
so that's a message we have to get out to attorneys too. Provide your comments. Be careful. Don't give all the facts of the case that the judges know. I know exactly who that is, but that is the opportunity to provide that.
Okay,
confidentially.
I didn't. I know
Yeah.
Senator Morrissey put that in his letter. I didn't.
Yeah, go ahead,
View it that way.
Senator Sherwood, is there a question?
Yeah, I'm getting to it, Mr. Chairman. So, first of all, I agree with Senator Morrissey that having the evaluator in the room, or if the judge knows the evaluator is in the room when the evaluation is being done, is not particularly helpful. There might be some administrative things that take place. The judge may be able to provide some comments. Hey, you could move these kinds of cases along faster, or you could, skip this part. You don't have to ask everybody to do a plea colloquy or something like that. But in terms of the judge's demeanor, the judge is not going to have bad demeanor when the evaluator's sitting right in front of them and they know it. And I was in court the other day when a judge who I thought was not the best judge in the world was sitting in the gallery, and I was like, what are you here for? What are you sitting here for? He's like, oh, I'm the evaluator. And I was like, oh my God, you're the last person who ought to be evaluating anybody. So,
Well, and it's not, they're the facilitator. So
or whatever
they're not-
it is,
they're-
I don't know how that's figured out either.
Well, so, and they don't do an evaluation then that gets factored into this or anything.
Well-
It's really to act as a resource for
Well,
that.
first of all,
judge.
I would encourage the court to perhaps consider the judges that rank higher as facilitators as opposed to the judges that might rank relatively lower as facilitators, because that also if that's how because that might affect whether somebody actually gets meaningful facilitation or not, number one.
Okay.
Okay?
Senator Senator Searle, is there a question?
Yeah, I got a question, Mr. Chairman, but I think it's a lot more efficient for me to give a bunch of feedback than to ask questions and then keep asking questions, so. But the question I have is, one of the concerns I've always had about the program is whether or not either gender or race bias might creep into the results that we get back. And because I've had a couple people comment to me that they're concerned that women might get evaluated, women judges might get evaluated differently, and that there might be, a racial bias in terms of how the results come back. And I took the last 240, and the men and the women came within 1% of each other in terms of their overall ranking, which I was surprised by. But have you all done any analysis of that to figure out? Because you're getting a lot of data now, and there's lots of different ways you could look at this to see if there's a rural-urban split, if there's differences in how they're looked at between circuit, GDC, and J&D, because I know a lot of the J&D judges feel like with the matters they deal with, they get rated much more harshly because they deal with some really tough stuff. And have you all looked at any of the data at all to see if, there's
No,
trends in the data?
I know that a couple of years ago, the change to the frequency-based was also done to address the gender bias that was out there. So it went from descriptive to frequency-based. I am not aware that we have done that sort of analysis with all of the reviews over the years and done a racial gender. And I think, though, but part of it is what we say that, I think evaluations, even among, from the same judge to same judge, even that, because you're going to have different evaluators. But when you start, then we end up doing what we suggest not to do, which is ranking them and stuff. But I think it would be something that we could take a look at. I will note that in this last round, we did look at, just a rough looking at gender. I don't think it's a instrument bias, because you have some judges that have ranked very high, women, judges who ranked very high, and then some who had a little lower. So the fact that you have those women who can then, who are ranking higher, I don't think it's necessarily an instrument problem. Now, whether it's a problem of the people who are completing the surveys, that's...
I think what you're saying is the aggregation that's the issue, data. Some people are good at doing evaluations or whatever, and others aren't. But if you get enough numbers, enough data, it comes together and makes some sense. Any further questions of Christie? If not, we'll go on to the next. Justice Powell?
May I just address
Yes,
one
please.
issue?
Thank you, Justice Powell, for
And
being here.
again-
Usually when I see a justice, may it please the court. But in that case, thanks for being here. We appreciate it so very much.
Thank you, Senator Edwards, and thank the entire committee for allowing us to be here. I want to ask you all a favor, if you will. I understand the concern about midterm evaluations, and I understand the concern about getting the information out so that the judges can improve their performance. And we want the best judiciary that we can have. And so that's why we have worked really hard at trying to get a product that will give us some good answers. But being a judge is isolating. And so once we put on that black robe, we don't know what the lawyers are thinking about our performance. We don't know what the citizens think about our performance. We don't know what the jurors think about our performance. We may have an inkling as to how well or how poorly we are doing, and I assure you, I don't think that there is any judge out there who sits on the bench from day to day and they decide that I'm just going to be the most incompetent, unfair, most impartial person that I can be today. But be that as it may, we don't have any of that information. I suspect you all probably have more of that information from your constituents in that first 3-year period, for example, for the general district, first 4-year period for the circuit court. And so what I would ask, because the judge, him or herself, may not have any real idea of how well or how poorly they're doing until they get that midterm evaluation. They get that evaluation, and for some of them, I suspect it really sets them back on their heels. They go, I had no real idea that this is the way I was being perceived. And so I would ask you to consider allowing that midterm evaluation to remain with the judge so that he or she can have a fair opportunity to look at it in black and white and go, oh my goodness, I had no idea that I was being perceived this way, and give them an opportunity to turn it around before you turn it around for them or threaten to turn it around for them. And give us an opportunity to work with them, which is why even before we get the letter from the judge in the Tidewater area, the committee had already addressed and proposed to the chief that we be allowed to put in this peer-to-peer program so that it gives judges another tool beyond the meeting with the facilitator judge, another tool to get it right before they have to come before you. And so if you would consider giving us that opportunity to help the judges help themselves from the knowledge they gain from that midterm evaluation, I think we would all be better served or well served by that. Whether you rank them or not, that's certainly up to you. We can't tell you whether to rank them or not. We've just given you some considerations as to why we think it may not be beneficial. Perhaps the case study of this lines up with what I see in court is more accurate than what we're saying, but we're saying from our perspective, because of the differences between rural and urban, small courts and large courts, in all circumstances, it may not be a good idea to rank them, but we recognize that we certainly, you do with that information what you choose. So those were my thoughts and my comments. Thank you for listening to me. I appreciate this audience. And I see this, I think Senator Morrissey may be trying to get
Senator
your
Morrissey,
attention,
you have a
Senator
question?
Edwards.
You have a question?
I do.
Okay, go ahead.
Thank you, Mr. Chairman. First of all, Justice Powell, thank you for your years of service on the bench in many different courts. I heard you very clearly that the first two evaluations, don't share them with anybody else. But what do you think about a compromise that those first two evaluations be shared with the Supreme Court? And you're correct, or Ms. White was correct when I misstated when I said the first two evaluations are only shared with the judge and the evaluator. But why not the Supreme, let the court see it as well? Because as Judge Martin said, if you just show it to the facilitator judge and just show it to the judge that's been evaluated, according to this judge that ranked 2 out of 50, he said it just may be, he said, a judge with a sense of self-importance can easily rationalize those first two reviews as representing disgruntled attorneys rather than accepting them as constructive criticism. But if it was sent to the court itself, then there may be an opportunity, at the very least, for you to get that type of mentorship to that judge before the next evaluation. What do you think of that idea?
And I think our peer-to-peer proposal comes close to what you're suggesting, Senator. Our peer-to-peer proposal, and it won't catch the self-important judge who looks at it and goes, they couldn't possibly be talking about me. I would hope that there are a few of those people out there. I would hope that when you all put us on the bench, you are weeding out the self-important people, except for the few who managed to slip through. But what this will catch is the judge who gets that report, and they go, oh my God. And so then they reach out to the court and ask that we appoint this peer-to-peer judge to work with them. That's how we envision the process to work. I won't rule out the prospect of the court looking at them, but you all have told us that we can't. And I'm not asking you to change that. But your legislation says that it is confidential. And we're not asking you to change it.
Thank you very much. Thank you, Mr. Chairman.
I just wanted to say something. When I think it was Bob McDonald came up with this idea of evaluating judges, I thought it was a bad idea because I thought it was going to be used for partisan reasons, and actually it was in some cases. And more recently, I think it's become a very good tool for legislators. When you see somebody that's ranked consistently high in every
Yes, sir.
category, then that tells you volumes, because there are a lot of people who are saying this.
Yes, sir.
At the same time, when you see somebody who's maybe ranking very high in some category, but really low, such as demeanor or something like that, and consistently, with a lot of people, that it really tells you volumes too.
Yes.
So I
yes.
think it's a good program, and I appreciate the court doing it and continuing to look at it to improve it.
And we appreciate the program. We probably came to it with a little bit of skepticism, kicking, screaming, don't make us do this. But we appreciate the program because, as I said, we don't know how the lawyers who come before us view us. We have an idea of how well we're doing, but until we see it in black and white, we really don't know. And so it does give us an opportunity to take a good reflective look at how others see us.
Yeah, we really appreciate your Justice Powell, you're taking your time to come.
Thank you all
and
for
be
having
with
us.
Good.
Thank you, really. Thank you so much.
Judge White, you next? Thank you too. Retired Judge White from the Lynchburg area.
I am, yes. I can really speak now as a retired judge to the difference in the legal culture from one end of the state to the other. And I've now participated in these evaluations from everywhere from Virginia Beach out to Dickinson County, Buchanan County, out that area. So it is incredibly different what the culture is. And in some instances, you can see the reasons people get evaluated differently. And it's not, even though we're there, they generally run court the same way they would run court, whether we're there or not there, in terms of the placement of people. Sometimes in small rural courts, there becomes a judge might be ranked on engaging in improper ex parte communications, and it's based on the fact that the prosecutor stands at the bench the whole time. And that's just the way they run their court. And when you see things and you're able to observe in the audience how it looks, like, for instance, the clock, I really thought that judge was looking out the window. And it particularly hit me when an attorney was making their closing statement. They had not a clue, and then realized that's the problem. You need to put the clock right directly across from where the judge is, not off to the side. But it's really been interesting, the things. And obviously a judge, if they know we're there, they can be on their good behavior if there's a demeanor issue. But quite often, you can see the reasons that these results are coming out in the evaluations, and you can make suggestions so that judge can improve what you see. So.
Okay, yeah, Senator Morrissey.
Thank you, Judge White.
No problem.
I fully agree with you that the culture in Buchanan County is different than Henrico County. I get it.
Right.
However, do you understand, though, that when the evaluations are done, we may have, like we had a few weeks ago, 5 judges evaluated from Virginia Beach area. They're being evaluated by that body of attorneys and bailiffs and clerk that exist in Virginia Beach. In other words, a group of attorneys in Buchanan County are not evaluating some folk in Buchanan and some folk in Virginia Beach. And those attorneys that are evaluating those 4 or 5 judges up for reappointment in Virginia Beach often say this judge is not courteous or not impartial, but the others are. So I think it works itself out in the wash. Wouldn't you agree?
Well, not necessarily, because you're really comparing apples to oranges. For instance, because Virginia Beach is such a large urban district, the rate of return on those surveys is significantly larger. You might get 100 and some returns versus 50 in a rural area. And the lawyer that has appeared before you once has the same opportunity to fill out the evaluation as someone who's appeared before you a lot of times. So in Virginia Beach, you could have 100 lawyers rank one judge and not have many of that same 100 lawyers rank a different judge. So it could end up being different in that regard. It'd be one thing if you had the same group of attorneys ranking each judge, the same people, then I think what you're saying obviously has some validity. But it can be very different. And then when you get to the rural counties, it's not going to be all people from that county, from Buchanan County. If you have a judge being ranked there, being evaluated there, they're going to be from all over that Southwest Virginia area. And the practice is different, even within that area. I've now been, I think, to 4 jurisdictions down there, and it is significantly different. And you might have the lawyers that regularly practice saying wise, but because they've gone to Tazewell, they can rate the judge in Tazewell, and they may do things differently there. as I say, particularly I've noticed the thing with a lawyer at the bench, lawyers being, or judges being evaluated saying that they're having ex parte communications. Well, they just set up their courtroom so that this person's always right there, and it does look like that. I can see why someone, if they came from another county where they don't do that, would think it looks like that. I can tell you, coming from my area, it's really interesting to see what you see in different courtrooms, because it's very, very different.
Mr. Chairman?
Senator Morrissey, go ahead.
First of all, thank you, Judge Ryder. Just a comment that I want to share with my colleagues. I agree that in some jurisdictions, the folks that appear, the attorneys that appear before a judge may be more folksy, and it might have a more informal atmosphere versus perhaps in Fairfax County where it's very formal. But at the end of the day, there's still an evaluation. And as I tell my children, if you're kind and polite in Pulaski County, you're probably going to be kind and polite in Henrico. The second point that I want to make, and I leave this just, judges, for my colleagues, but I think it's an important point. It's a very quick, short story. 2 days before Christmas, I got a call from one of my folks that work for me, a contractor's wife, who was in tears. Her husband just appeared in Stafford County on child support for an ex-wife. He went in there, and the judge ordered him to jail, and said, we'll next take this up on January 3rd, because he hadn't made child support payments. He had paid exactly what he was supposed to. English isn't his first language, but he speaks very well. He tried to say, Judge, I've paid $3,700, and I paid 4 installments of $1,000 for $7,700. The response was, you don't speak in my court when you haven't obeyed my orders. And he was hauled off to jail. And I called a couple of attorneys, get back in front of that same judge the next day, and I am so upset that that individual was treated in such a horrible fashion. And I would have liked another attorney that was in there that saw that to be able to evaluate and comment on it. That's all I'm saying. Don't want you to comment on it, but thank you for doing what you do. I know you're evaluating folks, and please, if you all, and Justice Powell and Ms. Wright, would consider the penultimate paragraph in Judge Martin's letter as to how we can help judges that are doing poorly. Because my questions during the vetting process weren't just to point out their defalcations, but rather to show, how do we make this better? How do we improve it? And Judge Martin gave a good suggestion. Thank you for your help.
Senator Deed.
Mr. Chair, when
Thank you.
this was first proposed, I certainly shared Senator Edwards' concerns, and I still do, honestly. One thing you said, and I'm not sure whether you're the appropriate one to respond to this or not, but one thing you said is and most of my practice has been out in these places where there are a lot of circuit riders. All the judges
Right.
ride circuits, handle multiple counties. One thing you said was that in some of those jurisdictions, you only have 15 people or so respond. One thing I've worried about is that the people that will respond are the people that get bad judgments, or judgments they don't agree with. And I don't know if there's any way in the world to measure that, to measure what percentage of the responses are coming from people that have a particular burr up there, or burr under their saddle. But that's what I've been concerned about. I mean, I hear what Senator Morrissey's concerns are. I mean, I've certainly known some bad judges too, some people that were rude in the courtroom, but I'm worried that a lot of the evaluations are being done by people that have particular reasons to be upset.
Okay. Judge White, yeah, Justice Powell?
Just to
Yeah.
address Senator
Either,
Deed's point.
anybody, go ahead.
Just to address Senator Deed's point, we believe the process works because they are anonymous. And so we couldn't know whether the 9 people who respond are the last 9 people who got a bad judgment or a bad ruling or whatever. Our belief is that the best way for the process to work is that they are anonymous, so that the lawyers and the other respondents will give their honest evaluations. And so we might have that situation, but if we keep it anonymous, there's no way we could know that.
Okay. Anybody else have anything else they want to say? Again, Justice Powell, Judge White, Christie, Wright, thank you both, all three of you, for being here and taking your time. I think this has been very valuable, and continue the good work. We thank you again.
Thank you all so very much.
Anything else coming before the committee? If not, the meeting's adjourned.